So maybe here I have to move to the last thing or last intervention, which is the Tunisian experience, the Tunisian attempt to provide a unified tax on the digital economy. And maybe, as I mentioned in the beginning of this webinar, Tunisia started in 2020. It's a struggle. It imposed a tax of 3% on digital services or digital economy. However, it was not really activated in Tunisia. Afterwards, was included in the inclusive and comprehensive framework of the OECD. And maybe this makes us wonder about the reasons why we did not imply this tax. And then, was it a recommendation by the European Union? What model Tunisia followed? Is it the ATF model? And then why did we not implement or apply that tax? Maybe because it was maybe because we joined the OECD initiative, which imposes that we get rid of any local initiative, or maybe because we have some challenges when it comes to the Tunisian administrations for the implementation and the application of these taxes. So, for all of these questions, we will have with us Ms. Habiba Louati from Tunisia, and she's going to share her point of view about that. Thank
Opportunity that you offer me to uh, reinforce our knowledge. I would like to thank very much all three speakers for their presentations to speak about the Tunisian experience. It's true that there is no that the lot budget for 2020 has stated it established a tax on digital services for 3%. This measure was not applied for several reasons. First of all, its application was pending a decree, application decree that was never published. The government decree was supposed to establish the modalities for payment, the procedures for tax filing and payment. And also for me, it's not that much. That's the most important aspect for me. What matters most is the scope of this taxation. Based on Article 27, it was established that sales of software and internet-based services are subject to a levy. And what really what's really strange is that they want these companies to come file their services or their income in relation to these services. If we were to discuss the scope of application for software, our internal legislation forbids the taxation of sales without having a permanent establishment. So you cannot establish a tax when the scope of the tax is not feasible, because if we do not have a permanent establishment, we cannot speak about the sales of software, because if it's a user right, then it's a service. But if the sales, this calls for a permanent establishment to be able to apply this tax. So this is already an issue with the scope of application of the service. Now, for internet services, nothing in our own legislation provides the application of the service. It's whether it's through conventional provision of services or remote services or internet-based services, you can implement this. And this is why I'd like to go back to the intervention of Khawla, which was very valuable, by saying that OCDE are confronting the issue of defining permanent establishment. For services, we do not need physical presence for taxation. We can tax services even if they are remote or digital, because it's a taxation that can be done through withholding tax, and nothing stops any company, state, or administration to tax these even without a permanent establishment. The issue with the ECD model is that it does not allow for taxation of services without a permanent establishment. So their model does not apply to the taxation of non-permanent establishment. And here we have the Article 12 that establishes a list that is exhaustive, unfortunately, of services that we can tax without physical presence of the service provider in the source country. So I like what the UN has done in Article 12, where they have introduced this idea, the concept of digital economy. That's a solution for me, as we have a definition that is conventional, because we have two ways of seeing things. For people who, for countries where we don't have a convention, we can apply this for all services. All we need is that the service consumer be established or resident in Tunisia, and so we can tax. We have our own system, and it covers both direct taxes, as our colleague from Nigeria said, or VAT. In both cases, taxation is easy, it's done, it's feasible, and actually, we have a system in our legislation. We ban the transfer of a part of the service if we are not able to demonstrate to the central bank that the tax was with the levied correctly. And so our legislation exists, and it allows for the implementation of a tax on digital economy. The problem is that I believe the problem is that we don't have, we're talking about GAFAM here. It's not the provider per se. For the provider, they have done, they have been remunerated, compensated for a service that was there. But for us, what presents an issue for us is how to tax GAFAs, meaning the mechanism used for the service provision, whether it's Google, Netflix. This is the issue. These people, these providers, they are, we cannot assess their turnover. How can we assess their turnover, the turnover of these providers? Because in every service, I think we have a triangle relation. You have the provider, the consumer, and you have the Google or Netflix or YouTube, who has allowed this transaction, the system, the canal of information sharing. So this is the issue. The tax implemented was to tax GAFAM and not these providers. But how was this established?
It's for services carried out on the internet. Yet nothing today prevents us from, taxing internet. So who am I taxing? I'm taxing somebody non-resident, for someone residing in Tunisia who's going to pay them for their service provided, no matter what are the resources used to provide the service, and the method used for payment. The withholding tax is here, and I think all legislations have this withholding tax principle, which is carried on all service providers who do not have a physical presence in the tax country. So the problem is not about the service providers. So this is why they called it a due, or but a levy. So the way this article was drafted, it can never be applied, no matter what. First of all, it talks about the sales of IT software and internet services. But the worst about it is it imposes or taxes these people who carried us to file their quarterly tax revenues. So if I know them, yeah, I can control them. But is it going to be a problem to make them to put in their statements and pay? No, that's not. But I'm talking about virtual entities. I do not know that I cannot control, that I do not know what their turnover is, the revenue is. I think this is with the problem with the digital economy. This is the problem raised here. It's not. The services provided in a wide, context. No, this is what I say. Unfortunately, we have this provision, as you mentioned it, that's been here for nearly 4 years, but cannot be implemented for multiple reasons. And in fact, even the decree for implementation has not been issued yet. I think that this article needs to be reviewed, amended. First of all, we need to review our legislation and try, first of all, to deal with this if there are any gaps. But for me, I used to work in the legislation department, and I know that the services provided by non-residents, no matter what their state, country of residence, they are taxable. Now remains the problem of the countries with whom I have agreements. I am limited by those. I do not have authority to impose all these. But practically, so in the for services in the term levy, we have legislation or conferences with technical fees or levies or for digital services. The notion of digital services is missing. It's not there. I think the best would have been, I think, as we did the multinational agreement that has which Tunisia has signed up. They should have updated the definition of the term levy or tax and include in this definition digital services. So that way they could have been able to save tax revenues while keeping a scope of implementation, because the largest part of digital services are carried out with countries with whom non-double taxation agreements. And even if this article has been drafted, it could never be applied for a country connected to Tunisia through a non-double taxation visa. Because my hands are tied, I have a very limited field of application implementation by this terms of I cannot come through my internal legislation to introduce a new tax or levy on services that are not included. That this was, performed. So even if this article were to be updated, modified, and better drafted, the problem for me remains still for all the resident service providers from countries with whom we have non-double taxation agreements. For me, it's not a problem of non-double taxation, but it's the issue is when they do not have a physical presence on the Tunisian territory, and they don't have permanent economic activity. Even if they are triple taxed, that's not Tunisia's problem, because the source country tries to preserve its rights to collect its taxes, if ever the scope of implementation allows it, and if the internal legislation also allows it. So double taxation, it can be avoided in case of residence, and so much as they can deduct what he paid in the source country in application of internal or domestic regulation, because we can never, as a source country, we can never worry about non-double taxation. Of course, in my experience, that is. And I don't know if you followed here for the issues for the implementation of this provision regarding digital economy as introduced by the tax law of 2020. Madam, are you still here? Yes. So yeah, ask me the question
Actually,
of
this
the
is what
why of this way, why this article was never implemented. And for me, and reading this provision leads me to be convinced that the article, as it's drafted, could not be applied. I'm pretty sure it's never going to be applied. It needs to be modified, and before it's reviewed to be modified, we need, of course, to prepare Tunisian legislative framework so that it can be adapted to this of this digital service revolution, as we call it. Thank you. Merci.
Actually, the problems for us when it comes to the digital economy, as it is mentioned in the financial law in 2020, it's how we draft this article and how we did not really review the conceptual note or framework of this article. So the PE, I mean, and how we consider the PE, the permanent establishment or enterprise, and also the our being unable to identify the revenues, the real revenues of these companies. And maybe, Ms. Habiba, you correct me, we had some bilateral agreements with our partners, uh, the partners to Tunisia, that hinder us from implementing this tax. Is that true? Yes. I do think that all countries around the world have the same problem, because when we talk,
We
we
have an
have a
agreement. What's listed in the department? The
convention.
services carried out online.
And now I'm switching to French.
What do we speak about this? What services are we talking about? When we have an agreement, the services I can apply are determined by the agreement, and whether via internet or not, that we can tax for one, two. We talk about virtual companies that are not here or that are not present. Can we request these companies to, file their taxes on a quarterly basis for their quarterly turnover? Yeah, it's impossible. Yeah, it's logic to ask them to do so, because I have no knowledge, I have no idea of their turnover, their revenue. I'm asking them to come and declare this and to pay these 3%. It's not feasible. So normally it should be a tax via withholding tax. I don't need them to come here. I can't make them come here anyways to file their tax returns. You can only force someone to come and file their taxes only if they have a physical presence. So I'm still a physical presence with a permanent activity. The notion of a permanent establishment, or it has to be proven to request the statements. So these are stable in the or permanent officers that have worked in Tunisia and they didn't pay their taxes. And we had to put in place a withholding tax also on these stable, businesses that we taxed to their clients in order to at least ensure the payment of tax. Even if you have a stable entity or a present entity, it's not easy, it's not obvious to push companies to set up, to have a tax presence and to comply with the tax obligations. It's impossible. It's very difficult. To prove this, in 2016, we realized that many foreign companies, they had revenue on Tunisian companies through stable entities that were not captured by the tax administration. And we also had to, even for stable entities, and a taxation through withholding tax. I know their clients, so I tax them. whether to, push their stable entity to comply with our taxation. So, or they as clients have to collect the taxes on the withholding tax on their turnover, of course, while given this stable entity the possibility to regularize their situation. And in this case, we may refund excess, any excess withholding tax we may have received. So just to say, the fact just because you have a stable entity or office doesn't mean that the tax recovery is going to be possible. I, on the other hand, have pushed a lot for the multinational agreement and especially assistance for recovery. So if we have such entities, this can help with the adequate collection of taxes in the case where countries assist each other to preserve the rights and the tax resources of each one. This would have been a very good initiative if ever this provision would be implemented and assistance would be operational. The assistance for the collection would even now, and even with conventional economy, we see a lot of fraud, a lot of evasion, and lots of non-taxation and the impossibility to collect the tax per se.
Thank you, my dear. So uh, now when we talk about the problems, these financial problems, you think that the solution should be multilateral solution. That's what I understood out of your presentation. So here I have a question, my colleague. So Dr. Leila mentioned that before. Tunisia is one of the consumers of the digital services. And Tunisia is one of the countries that is mentioned in this, let's say, global system. And Tunisian market is providing or does provide a lot of opportunity for these companies. So we have a lot of resources that we can lose. And maybe for the multilateral solutions, they cannot really bridge this gap. For the term, I think that they cannot be applicable. What do you think about that, especially in relation to the OECD? Maybe the best solution is the OECD solution, and its framework, or maybe we have to wait until we receive the protocols of the UN agreement for tax cooperation. And from another point, can you think about some experiences that could be successful in the implementation of unilateral solutions? Like, for example, we had Nigeria, Tunisia can build on that model. So what do you think? Do we have other models like unilateral solutions in other countries that we can build upon and we can follow, like, for example, the model of ATAF, which was issued even before getting into a lot of discussions in relation to the reforms, the global tax reforms. So how can we have a national tax on digital economy, and how do you read all of these questions, and how can you answer them on the short and medium term? For Tunisia, of course, what can Tunisia adopt or rely on in order to stop the loss of these revenues, tax revenues, I mean?
As I just explained earlier, if we talk about income tax on profits, and as I said earlier, anyone, no country that's connected so by a country with a non-double taxation agreement, they can tax. I'm talking about income tax. So to implement maybe a levy, yes, maybe this is outside from the agreement. So with an agreement, so we can set up an indirect taxation or a levy. This can be done. That would be in compliance with the agreements. We have agreements. All of the countries have agreements of non-double taxation, and I wonder how Nigeria was able to apply this levy or tax because earlier our colleague mentioned tax on profits and VAT. On VAT, there's no issue because it's the Tunisian consumer that covers this. So I'm talking about, you know, income tax, corporate income tax for profits. So we say, so yeah, you're saying Sahar says, oh, we're losing lots of fiscal tax revenue. No, I'm not losing. I do not have the authority to tax such a service because for the indirect taxation, I always lose. So, as I said, what does the agreement deal with? It covers the possibility to tax via a stable entity, which this is not the case. Also, the possibility to tax a service when the service is under the definition of taxable services in the source country. So either if I'm either a stable entity, neither under the service targeted or included by this or for that, how do you want me to be able to impose these multinationals that have massive turnover through the digital economy? No, I cannot. I do not have authority to do so. So if I don't have the agreements, I don't have problem. But if I have a non-double taxation agreement, all non-resident companies are taxable on all services, no matter what types, through withholding tax. In fact, we have two withholding taxes. We have withholding tax of 24% for countries with the privilege tax, and we have a rate of 15% for others. As I said, our taxation does not prevent taxation. For us, we have somebody who owes, who's going to pay for the services they used, and they have the obligation to do a withholding tax for the Tunisian treasury. This is our legislation. I do not have to look for, split hairs. The problem that remains, it's a problem of agreement. And also we have agreements with the majority of countries out there. And in application of the agreement, I do not have authority. And as such, earlier, Mrs. Khawla said that the United Nations have introduced the notion of digital services in Article 12. And Article 12 is levies. And so because now there isn't a regulation that allows us to tax. So if we change the way we're going, instead of talking about, income tax, we talk about taxation through an indirect tax or levy, that we will have a better chance. But we need to look at this into a more general framework. Then I will no longer be limited by the non-double taxation agreements, and I'll be able to tax. I'm going to have to find out how I'm going to do it, who's going to pay this tax, how am I going to collect it, who is taxable, who can I request it from in case of audit, how do I do it? So this is how we should do it. But to say that we can set up a tax on digital services, and the existence of a non-double taxation agreement, I don't see how we can. We do not have authority because all these agreements are the same thing. Either you have a stable entity or you're carrying out payments that are limited by the agreement. So how can we introduce another taxation? That's not feasible, simply. Frankly, it cannot be done at all.
Very clear. I just wanted to go back to Khawla. I think she was going to respond with regards to this point, and then we give the floor to Dr. Laila in very few minutes to react with the rest of the questions or points. Khawla, go ahead. Really, after what Dr. Habiba, Madam Habiba said, she explained very well why it's not possible to implement this article. There is no legal grounds for application. I have nothing to add. She is my professor, and I learned from her. I have the same idea, but she said it all. She said it all. We have to wait to see for the next phase. We monitor and wait more than we find solutions, because it's not related to solutions that are ready made, but it's rather about the possibilities. To what extent can we amend? There's no way we could let go or neglect these agreements? How can we levy these taxations without touching on the legal guarantees?